a lot of what I'm saying today is going to be framed by some of the recent consultations that I've done across the state. Quite shocked as we've come to the question in the IEP when we're considering whether or not the child needs assistive technology, that often the team really does not have a clear understanding of what assistive technology is. For example, at one of the last eval team meetings, one of the team members said to me when we said, yes, this child does have a need in the area of assistive technology, she said, but he doesn't need a device. And I said, no, he's a very literate, very vocal young man who has age-appropriate speech and language skills, but he has a significant disability in the area of learning. So for reading and writing, this young man needed assistive technology. And what we were recommending for him was not a device. She said that her previous district had said that the only time they could say yes on the IEP was if the child was going to need a device. Now, if the child needs an assistive technology device, yes, you also do check yes on the IEP, but there are a lot of assistive technology tools and practices out there that we can use with the child through the IEP process that are not device driven, especially the last 10 years when we've gone to cloud-based assistive technology and are no longer installing software or bringing special like portable word processors or some of the tools like that for reading and writing. So I'm going to pop to our page on the law and the legal requirements and just quickly cover some of the legal requirements about assistive technology. And again, there's more on this page that I'm going to cover in the short time frame we have here. But every school district is required to ensure that assistive technology devices and services are provided if needed by a student in order to receive their free and appropriate public education. This can be done through the child's special education, through the related services, or as a supplementary aid and service. It's very interesting the last few years. I used to always see it as included under special ed. So the legal requirement can be written into the IEP as special ed, as a related service, or as supplementary aids and services. Most recently, I've seen it as supplementary aids and services, which is a switch for me, but legally can go under any of those. If you look at the definition of assistive technology device, it doesn't necessarily mean an augmentative communication device. It means any item, piece of equipment, or product system, whether acquired commercially off the shelf, modified or customized, that's used to increase, maintain, or improve the functional. That part of the law has not changed. It's very, very broad. So it could be as simple as a sheet of paper that has glue on it, so a student with visual impairment knows the borders of the line of paper, of the sheet of paper, or it could be a high-end augmentative communication device. What is assistive technology service? Basically, it's the evaluation of the child's needs, providing the device. Now, the district needs to provide the device or the technology that we need for the student. They can purchase it, they can rent it or lease it, they can make it if it's something that somebody in the district has the skills, where it's something that can be sort of a DIY project. That's all legal and okay. It's whatever works for the student. The district is also responsible for making sure that that technology or that whatever we've identified is appropriate for that student. So it may be customized, it may need to be fitted. In the example of a student with learning disabilities, maybe that means using a word prediction tool for them, but front loading that word prediction tool with the vocabulary or the types of concepts that they are going to need to write about. That's customizing the assistive technology for a student. For a student in speech and language needing an augmentative communication device, that's customizing some of the language that may come pre-programmed into a device. We are also responsible for training and technical assistance for the child, and where appropriate, the child's family. So often we do need to bring mom and dad or siblings in and say, this is the tool that we're going to use to encourage writing or to do homework, and this is how we do it. And then finally, training and technical assistance of you, the educators. And that's one reason for this webinar today, and that's another reason why your district support you're attending some of the professional development activities, because it is important as a special educator that you do have a knowledge of assistive technology. I also linked, and I didn't check to see if there was a newer one, but the NIMAS, the National Instructional Materials Accessibility Standard. A bulletin was published by the department last January that was sent to all your school districts that updated them on the NIMAS standards. So that information is also there if you need that information. Another question I often get asked by school districts is, who can do this assessment? Paula, do we need to hire you because you're an AT consultant? And the answer is no, you do not need to hire me. Anybody who is knowledgeable in the area of assistive technology and special education can conduct that assessment. Often it is a speech and language pathologist or an occupational therapist or a special ed classroom teacher. I worked with assistive technology people who are technology integrators. They really know technology and they somewhat have an understanding of special ed, and they've served that role also. When we form our team, because assistive technology is not something that the AT person comes in and alone and does, you are so reliant on the other individuals who are working with the child. And one of the core reasons for this is assistive technology transcends all areas of the curriculum. So it's not like as a speech and language pathologist, I really look at communication, language functioning, articulation, and voice, and some of those areas. With assistive technology, I need to look at activities of daily living, reading, writing, communication, accessing the curriculum, making sure that that student has the technology they need to function in their life. There is no test, no standardized test that is out there that I can give a child and look at their standardized score and plot it and say, yes, they qualify for assistive technology, or no, they do not. It is a team decision where we look at the tools that are available, we look at trial use of the tool by the student and see if that indeed help improve the functioning of the student in the area that we are addressing. So it's a very non-precise, I guess, area, unlike some of the areas where we look at standardized scores and we can plot and say, yes, they qualify, or no, they don't. Our teams, we involve anybody in the team who has knowledge about the child. We've already had crossing guards volunteer to be on the team because the child walks home from school and the crossing guard wants to know how to communicate with the child or how to help that child who has autism get across the street appropriately. They might end up at the assistive technology brainstorming meeting where we're looking at the needs of the child. Or the nurse. I've had physicians who have taken time to come into the meeting to help us brainstorm about the student. Anybody who has good information concerning the student can be involved in the decision-making process. Every to have procedures published on how they will provide assistive technology assessment. So that is one thing. If you're in a district that tends to say, well, we don't really do that here, you might just talk to your director of special ed privately. You may want to talk to some in your district and say, well, I understand that there should be a process or a procedure. About 15 years ago, every school district needed to have a technology plan that was approved by DPI, and part of that technology plan was your AT procedures, but that technology plan requirement has gone away. So that your procedures for providing AT assessments may be an old document that maybe sort of brought up to the front again and reinvented and looked at least to have the discussion amongst your special ed departments on how are we going to address when a student needs assistive technology. So in a nutshell, the law says that if a student needs assistive technology and they have a special education or a special ed disability, the school district needs to provide for that assessment. Again, anybody who is familiar with the student can indeed do that assessment.